Ma'am, the streaming is on.
Is being publicly streamed.
Okay, we can start. Right. Okay. So, dear participants, welcome back again. We will now officially start with the first session of this faculty development program. For this, I have the immense pleasure to invite Associate Professor Dr. Anish Pillay from the University of Cochin, who will be addressing us on international human rights law. Just to give you a brief introduction of Dr. Pillay. So Dr. Pillay is an associate professor at the School of Legal Studies, Cochin University of Science and Technology. He also holds the position of coordinator of the Justice V.R. Krishna Iyer Chair on Human Rights at the Cochin University of Science and Technology, Kerala. His academic excellence has been recognized remarkably with numerous awards, including the prestigious Distinguished Young Faculty Award for the academic year 2018 from CUSAT. He has also been honored with the Professor A.T. Marcos Memorial Gold Medal for securing the first rank in LLM, alongside the K.C. Menon Memorial Gold Medal for being the best student in LLM from CUSAT. He was also awarded a postdoctoral fellowship from the Mediterranean International Center for Human Rights Research, Italy, and in 2023, he was the recipient of the INSIG 2023 fellowship at the India School of Internet Governance. Dr. Anish has made notable contribution to legal scholarship through his authorship and editorial work. His notable authored books include Surrogate Motherhood and the Law, the Narcotics, Drugs, and Psychotropic Substances Act 1985, Artificial Intelligence and Legal Innovations, and State Responsibility under International Law. In addition, he has served as editor for several scholarly volumes, and his scholarly activities extend equally to participation in numerous national and international conferences, workshops, and training programs. Notable among these is the ICN-funded Train the Trainers program in Colombo, Sri Lanka, the international conference at Dhaka International University, jointly organized by Cyprus University, University of Sarajevo, Turkey. He has also engaged in workshops and conferences across the globe, such as Netherlands, Israel, USA, South Africa, amongst others. In addition to his academic and research contribution, Dr. Pillay has a rich experience in adjudicating national and international moot court competition, such as the Stetson International Environmental Moot Court Competition, Philip Say International Law Moot Competition, and the International Criminal Court Moot Court Competition. He has also crafted moot court problems in areas such as competition law, environmental law, and human rights for various national level competitions in India. On this note, please join me in welcoming Dr. Pillay for his address. Thank you, Dr. Pillay. The floor is yours.
Thank you. Thank you. I hope I'm Yeah, am I audible?
Yes, you are audible, sir. You're visible perfectly, sir.
Right. Right. Let me share my screen. So I hope my screen is visible.
Yes, it is. We can now see it.
Just a check. Did the slide change?
Yes, sir.
Yes,
So the slides are moving.
Okay. So at the outset, let me thank Bhavana Madam of the Mauritius University, as well as Central University of Karnataka, for inviting me to this wonderful faculty development program. Well, as the world is celebrating today, World Human Rights Day, I feel privileged to deliver a talk on international human rights law. So a special thanks for scheduling my session on this occasion of World Human Rights Day. Well, I will be speaking today about international human rights law. In this discussion or in this lecture, I will give a brief idea about what is human right, what are the characteristics, its development, and major treaties. Then finally, the application of human rights in India. So that is the structure of my presentation. Let us start with human rights. What is human rights? The idea of human rights. If you look at United Nations, they have given a small definition for human rights. That is, human rights are those rights which are inherent in our nature, without which we cannot live as a human being. So, if you look at this definition, though we have many number of definitions for human rights, this definition is the most appropriate definition for human rights, according to me. See the wording. Human rights are those rights which are inherent in our nature and without which one cannot live as a human being. So whatever rights we need to lead a human life, those rights are collectively known as human rights. The most beautiful description about human rights. And if you look at the way in which human rights is articulated by various international human rights documents, and which is incorporated in different national level constitutions and judicial decisions, they all treating human rights as something which are essential rights without which one cannot live as a human being. And if a person is deprived of his human right, his existence will be a mere animal existence. So that is why I said this description or this definition is the most beautiful or comprehensive definition for human rights. So once again, I will repeat, human rights are those rights which are inherent in our nature, without which we cannot live as a human being. So all those rights which allow us to lead a human life, we will call it as human rights. And because of that inherent nature, human rights are fundamental and they are inalienable. So whatever human rights we are seeing now, they are all fundamental as well as inalienable. So that is the basic idea of human rights. Having said what is human rights, let us look at the characteristics of human rights. Because we always hear different types of rights: statutory rights, legal rights, constitutional rights, fundamental rights, now human rights. So is this human rights and legal rights are same? Whether the human rights and statutory rights are same? Whether fundamental rights and human rights are same? So this question is always there. So when we learn or when we read about human rights, we have to be very clear what is the real nature of human right when comparing with other rights. So I am sure many of you might have teaching human rights or studied human rights. So can anybody enlighten us regarding the difference between a statutory right and human right? Can somebody please come forward?
Sir, may I?
Yes, please. Yes,
Yes,
please.
please.
Sir, I think human rights are inherent rights. That is right
Yes.
from the time when we are born, we have some inalienable rights, such as,
Okay.
for example, right to life. So this is the
Okay.
basic human right. So that is my understanding of human right. And statutory
Fine.
right is something which is laid down by a statute.
Correct. Correct. That is true.
Correct.
That
That
is
is
true.
Thank you.
So we will go with the fundamental right. So we have fundamental rights in India. So do you think the fundamental rights in India and human rights are same, or is there any difference? Can anyone please enlighten us?
Yes, sir. May I?
Please go ahead. If you could introduce and speak, that would be ideal.
My name is Dr. Ashok Kumar Sharma, Faculty of
Okay.
Law, Merit University, and
Okay,
I would
okay.
like to answer your question, sir.
Please.
The fundamental rights are covered under Constitution, and Article 32 guarantees that there is a procedure that after infringement of any fundamental right, we can go to High Court or the Supreme Court. In 226, in Article 226, we can go to the High Court, and under Article 32, we can go to the Supreme Court. But when we come to the human rights, there is no such dedicated law to make it happen. For it, municipal law should be there. So that this is the difference between fundamental right and the human right.
Fine. So we know now the difference between human rights and fundamental rights and human rights and statutory rights. So one can identify whether a right is human right or statutory right, or is it a fundamental right, by looking at the characteristics of that right. So what are the characteristics of human right which makes different from other rights? The first character is inherent nature. Human rights are inherent rights. That means when a person taking birth as human being, or simply you born as human, you are entitled to certain rights. There is no other qualification for claiming human rights. Only one qualification, that is, we have born as humans. So since we have born as humans, we are entitled to have certain rights. Those rights are human rights. That is why it is considered, or we are saying, human rights are inherent in nature. Now, second characteristics is fundamental. Human rights are fundamental rights in nature. Why it is considered as fundamental in nature? Because without human rights, our life and dignity will be meaningless. So if a person wants to lead a human life, he needs human rights. So in that sense, human rights are identified as fundamental in nature. Now the third characteristic is they are inalienable. Human rights are inalienable because they cannot be rightfully taken away from a free individual. You cannot take away human rights from others, or it cannot be forfeited. They are inalienable because without human rights, you will be leading a meaningless life. Now, finally, human rights are universal in nature. Universal in the sense, irrespective of your origin, irrespective of your status or place or race, whatever it is, wherever you born, you are entitled to have a set of rights. Whether
Sir.
you are in America, whether you are in India, whether you are in Mauritius, whether you are in Africa, wherever you are, whatever be your religion, whatever be your political affiliation, whatever be your ethnicity, irrespective of all these, you are entitled to have a set of rights. Simply
Sir,
because,
sir, excuse me,
please.
sorry for interruption, sir. I think
Please.
your PPT has been disconnected.
Disconnected.
Yeah, it is not been visible now.
What about others?
Same, sir.
Yes,
No,
it is
sir.
not visible.
PPT is not visible.
Oh,
Same, sir,
I
same.
don't know. But in my screen, it is showing like that.
Is the share screen option still on, sir?
Yeah, in my screen, the PPT is still on. Yeah, now 1 second, I will stop and
You stop and select entire screen, sir.
maybe some connection problem. Let me. What about now?
Yes, it is now perfect, sir.
Yes, sir, it is
Now
visible.
it's okay. I think the problem is
Okay,
when
clear
I'm
now.
making it in full screen, it is not coming properly.
Yes,
So I will
sir.
not make it full screen. I will use it this way. Okay.
Okay, sir.
So that's what I'm saying. What we were discussing is the characteristics of human rights. I hope that is clear for everyone. They are inherent, fundamental, inalienable, and universal in nature. Now, again, if you look at human rights, we have some more characteristics. Like human rights are equal and not discriminatory. That means human rights are available to everyone without any discrimination. Wherever it is, whatever be your legal status, human rights are equal and not discriminatory. And another characteristics is human rights are justiciable. That means if it is violated, you have a remedy. So whenever there is a violation of your human right, you will get a remedy. There will be some law to protect your right. Then human rights are not absolute. That is very important. When we talk about rights, every rights having some restriction. So likewise, human rights are also not absolute. There are many restrictions attached to human right. That is in the interest of public peace, social decency, political security, etc. So there are some grounds on which human rights can also be restricted. Then indivisibility. Human rights are indivisible. We have many classification of rights like civil rights, political rights, economic rights, social right, cultural rights, etc. But whether one right can be separated from another, that is very difficult. Sometimes civil and political rights will go hand in hand or one and same. Sometimes civil and economic rights will be one and same. So most of the time, it is very difficult to identify or pinpoint what is a civil right, what is an economic right, what is a political right, because it is indivisible in nature. And there is no hierarchy also. Which right is more important? Whether it is civil right, whether it is political right, whether it is cultural right, all rights are equally important when it comes to human right. But if you look at our fundamental rights in our constitution, civil and political rights are given more importance. Hence, they have made justiciable. But when it comes to social, economic, and cultural rights, which were placed in the part 4 of the constitution, which is not justiciable. That means civil and political rights containing in part 3, that is fundamental rights, are justiciable and the other rights are not justiciable. But when it comes to human rights, there is no hierarchy, all are equal status. Then finally, human rights are interdependent and interrelated. You cannot enjoy one right negating other right. Or in other words, you can enjoy human rights as a collective way. Means if you want to realize your right, you need many other rights. Like right to life is a fundamental human right. If you want to enjoy your right to life, you need right to livelihood, right to work, right to rest, right to entertainment, right to sleep, and many other rights. So that is why it is being considered human rights are interdependent and interrelated. So these are the characteristics of human rights. Now, what is human rights and what are the characteristics? That's what we were discussed. Now, let me show you a picture. Can anybody help me or can anybody explain what is this picture? Someone can try. Any idea?
Sir, I think something is written on a wall or like that thing.
Okay. Any other answer?
Manuscript of
So
any
this is a Cyrus cylinder.
manuscript.
So is
Okay,
this
somebody
Cyrus
said-
cylinder, sir?
Yeah, somebody said Cyrus cylinder. That is correct. What is the significance of Cyrus cylinder? What is it?
The first human rights, codified human rights has been taken from this.
Okay. Let me tell you. That is correct. The world's first Bill of Human Rights, which was discovered on a clay tablet, which is in the form of a cylinder. It's a cylindrical shape. Back to the reign of Cyrus, the great king of Persia. This Cyrus cylinder is considered as the first record of human right. Because in this cylinder, though it is a clay pot or clay cylinder, there were descriptions about human right. So that is why Cyrus cylinder is considered as the beginning point of human rights in the world. And associated with this Cyrus cylinder, there was a charter issued by the great king of the Cyrus, the king of Persia. That is known as Charter of Cyrus. So these Cyrus cylinder and Charter of Cyrus, actually whatever is written in this cylinder is what is the Charter of the Cyrus. It's like a document. At that time, they were using this type of mechanism to write it down. So this Charter of Cyrus, which is described in inscribed in Cyrus cylinder, is considered as the world's first Bill of Human Rights, or the starting point of our human right is Charter of Cyrus. And interestingly, in this charter, the right to liberty, religious tolerance, freedom of movement, freedom from slavery, etc., were described. See, this is a document created in a clay tablet or clay cylinder, that too in 555 BC, where you can find there was a right against slavery, there was a right against right to freedom of movement, etc. So that is the beginning point of our human right when we talk about the history and development. And the next history of human right, or the non-history of human right, was the Code of Hammurabi. He was a king of Babylon during 2000 BC. And this was the first written code in connection with human right. So the Cyrus cylinder and Code of Hammurabi is considered as the starting point of the present day human rights. Now, if you look at the subsequent development, we have many religious cultures in different parts of the world. We had Assyrian laws, Hittite laws, we had ancient Indian Vedic literature, etc., Bible, Quran, and all other religious texts. All these ancient legal systems and religious text contains some form of human rights in different way, but some form of human rights were there in these ancient legal systems. And after this ancient system or Vedic period in India, if you look at the modern period, you can find Magna Carta. That is actually considered as the modern beginning of human rights in the world. This was a document issued by King John in 1215 in England, which is considered as Great Charter of Liberties. So this Magna Carta is considered as the foundation of modern human rights. And proceeding further, there were many documents because of the influence of Magna Carta in many parts of the world. Different instruments were established, like a golden bull. That was another document in 1222. But in some books, you will find some books you may not find. They were all, some descriptions were there. So likewise, many documents emerged, and one of the notable document subsequent to all this development was Bill of Rights, established by English Parliament in 1689. Then subsequently, there were many developments, not only with respect to human rights, with respect to other branches of law, especially international law and environmental law, etc. So during that time, there were many jurists like Hugo Grotius, Machiavelli, etc. They had created or they had written books compiling the existing legal scenario of that time. So one of such codification is De Jure Belli AC Paces. This is written in 1625. Its meaning is, or its English translation is Laws of War and Peace. And this book is considered as the foundation of international law. And if you look at this book, there were many instances, many verses about human rights. So this book is also considered as one of the very important milestones in the development of human rights. Then subsequently, we had many school of thought in law. Since you are all studied jurisprudence, you know very well, we had many jurisprudential thoughts like natural law school, we had positive school, we had sociological school, economic school, etc., etc., etc. So through through these school of thoughts or jurisprudential school of thoughts, the human rights started developing. But interestingly, at that time, the term human right was not used anywhere. During that time, our human right was known as natural rights. So if you look at the jurisprudential thoughts at that time or schools postulates, you will find many references about natural rights. You will not find any references about human right, because the term human right is of later origin. That is why. But during that period, especially 17th and 18th century in Europe, many philosophers concentrated on the concept of natural rights. And they have identified the sources of natural rights, they have identified the significance of natural rights, content of natural rights, restrictions of natural rights. So through this process of identifying the concept of natural rights, the Western thinkers developed slowly the idea of human rights. And subsequently, the idea of natural rights more prominent through theory of social contract. I think everybody knows theory of social contract, so I'm not discussing that. But the idea of social contract or the theory of social contract propounded by John Locke further strengthened the development of human rights in the name of natural rights. Then subsequently, we have witnessed, or the world have witnessed, American Declaration of Independence in 1776 and French Declaration of Rights of Man, 1789. Now, interestingly, during this time, during this American Declaration of Independence and French Declaration and subsequent adoption of American Constitution, if you look at the concept of rights of man or rights of men was emerged. And there were no human rights, or the idea of human rights was not there. The rights were conferred only to men and not to women also. Because at that time, the legal systems were under the idea that men includes women, or men and women are equal. So there were no rights as such conferred to women, but the rights were conferred only to men. That is why almost all documents at that time were titled as Rights of Men. And subsequently, in the 20th century, especially after the establishment of League of Nations, we have seen the world has thinking about creating international instruments for protecting the rights of men. So they had adopted number of international treaties during that time, especially the Declaration on Rights of Child, 1924, was adopted under the leadership of League of Nations. And during that time, International Labour Organization, that is ILO, that was also established. And ILO also adopted number of treaties to protect the rights of laborers. Then International Slavery Convention, which was adopted under the leadership of League of Nations. All these conventions were created a trend or made, or these conventions shown to the world that international community can create law for protecting rights. Then subsequently we have seen Second World War. In fact, the Second World War and the reasons which led to the Second World War has influenced the international leaders, then existing international leaders, to think about establishing a strong mechanism to regulate the conduct of nations. So right from 1941, at that time the World War was ongoing. So right from 1941 onwards, the international leaders, especially Winston Churchill and Roosevelt, they discussed about creating a body which can control the nations and their behavior. So that discussion, they continued through many series of conferences like Atlantic Charter, Dumbarton Oak Declaration, San Francisco Conference, etc. So finally, international community succeeded in establishing United Nations in 1945. Now we can say establishment of UN is the direct result of Second World War. Now, how United Nations establishment helped development of human rights? If you look at United Nations Charter, you will find 7 references about human rights in UN Charter. 7 references. And one of the objective of UN is protection of human rights. So because of that, one of the first decision of United Nations was to establish a Human Rights Commission. So UN had established a Human Rights Commission under the leadership of Eleanor Roosevelt. And you will find in that commission 3 Indian women were included: Hans Mehta, M.R. Masani, and Lakshmi Menon. They were also members in drafting the Magna Carta of Human Rights, that is Universal Declaration of Human Rights, 1948. And this Hansa Mehta, she is having a very good significance. Why? Because can anybody tell me what is her relevance or what is her significance compared to other 2? If anybody know? Anybody can try.
Sir, please repeat the question.
See, out of these 3 names, Hansa Mehta having a significance. She was a member of draft committee of UDHR, as well as
Yes.
anybody?
He was a member of Constituent Assembly as well.
Correct. She was a member of Constitutional Assembly.
Yes.
Our draft constitutional. She was a member of draft committee of UDHR. At the same time, she was a member of Constitutional Assembly also for drafting our constitution. So that is the significance of Hansa Mehta. So through the effort of Human Rights Commission, they had established Universal Declaration of Human Rights, and it was adopted on December 10th, 1948. And India was a founding member also in that. Then, subsequently, there was a discussion. If you look at UDHR, we will discuss that after some time, but still, if you look at UDHR, it's a compilation of civil and political rights as well as social, economic, and cultural rights. And since it is a declaration, it is not binding. It is left with the discretion of the nations to implement the rights. So international community thought about creating a framework at international level which will make mandatory to the member nations to guarantee human rights in their country. So what international community did, they thought about making a binding international human rights treaty. So initial idea was converting UDHR as a convention. But during 1950 to 1960, during that period, there was Cold War was going on between Russia, USSR and America. So the international politics was also something different. So they could not reach a consensus about converting UDHR as a binding convention. But the member nations, or at that time, the major nations were ready to accept one point, that is, they can make civil and political right as a mandatory document. But when it comes to social and economic cultural rights, it cannot be made mandatory obligation. So finally, international community agreed to adopt two documents. One consists of civil and political rights, and another consists of social, economic, and cultural rights. That is why in 1966, International Covenant on Civil and Political Rights was adopted. At the same time, International Covenant on Social, Economic, and Cultural Rights were adopted. Both of them were adopted on December 16th. Now, if you look at ICCPR and ICESCR, there is a fundamental difference. The difference is ICCPR is a binding international human rights law. So the member nations are bound to incorporate whatever rights listed in ICCPR in their domestic level, or they are supposed to make appropriate amendments. But when it comes to rights guaranteed under ICESCR, it is left with the discretion of the countries based on the economy and resources. The countries can decide whether to guarantee these rights mentioned in ICESCR. So likewise, the international community adopted ICCPR, and both these documents came into force in 1976 onwards. And subsequent to this, we have seen international community adopted large number of human rights instruments. Large number of instruments. You can see a list of important documents, but this is only an indicative list. If you look at the website of UN, you will get more than 100 international human rights treaties. That many number of human rights treaties were adopted. Even ILO itself has adopted somewhere around 60 to 70 human rights treaties. Now, all these developments which has happened at international level led to the idea of International Bill of Human Rights. So when you read any literature on international human rights, you will come across this idea, International Bill of Human Rights. Now, what are the components of International Bill of Human Rights? Starting from UDHR, then secondly, ICCPR and ICESCR, and thirdly, two optional protocols adopted in connection with ICCPR. Now, there are many books, if you read human rights, many books, you will find a difference regarding the content of International Bill of Human Rights. Some books say these three are the first three documents are the Bill of Rights. Some books are saying only first optional protocol will be considered. And majority of other books will say both the protocols will be considered. So whatever it is, International Bill of Human Rights includes UDHR, ICCPR, ICESCR, and optional protocols. That is what I could say. Now, this is the idea of International Bill of Human Rights. When the international community started adopting many human rights treaties, UN also got doubt. Which one will give more preference? Which is more important? Because many number of international treaties were adopted by the member nations. So finally, what UN did, UN has identified 8 international human rights treaties as the core human rights treaties. 8 international human rights treaties were identified as the core human rights treaties. And all other treaties are directly or indirectly connected to either of these core human rights treaties. That is what, if you read many treaties, you can make out a connection with any of these 8 human rights treaties. Now, what are those 8 core human rights treaties? You can see in the screen. First one is International Convention on the Elimination of All Forms of Racial Discrimination, ICERD. Second is ICCPR. And third is ICESCR. And fourth is CEDAW, Convention on the Elimination of All Forms of Discrimination Against Women. Then Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment. Then Convention on the Rights of Child. Then International Convention on Protection of Rights of All Migrant Workers and their members of their family. So these were considered, these 8 treaties were treated as the core human rights treaties in the world. And all other treaties are one way or other way related to this. Now, for all these 8 human rights core treaties, there are inbuilt mechanisms for its enforcement. If you look at first one, we have human rights committees there. We have economic, social, and cultural rights committees there. We have elimination of racial discrimination committees there. We have CEDAW is there. Committee Against Torture is there. Committee on the Rights of Child is there. Committee on Migrant Workers is there. That means all these 8 human rights treaties contains bodies to implement and to supervise its violations, etc. So they are considered as treaty bodies under international law for dealing with protection of human rights. Now, as I said, we have number of international human rights treaties. We have 8 core human rights treaties, and we have treaty bodies. Now, obviously, a question comes: how we are going to enforce human rights? What are the methods of enforcing human rights? We have 3 mechanisms. All these treaty bodies allows 3 methods for enforcement of human rights. First method is state reporting. If you read these conventions or treaties, you will find an obligation imposed on every member nation. That means every 4 years, member nations are supposed to inform UN and this treaty body about the implementation measures they have taken in their country. So whatever measure a country has taken in their country for implementing the rights of this convention, it has to be reported periodically to the UN through these bodies. Now, interesting thing, when a government reports giving update about their implementation status, this document will be available on public through the website of these bodies. Anyone can go through that, and if there is a false claim, can notify that or point out that. So because of that, countries will do something, definitely, then they will give the report. Otherwise, it will be scrutinized by many NGOs and public spirited persons, and they will point out the false claims. So state reporting is considered as the most effective way for implementing the provisions of these international human rights treaties. Now, the second method which is provided in these treaties is interstate communication. Well, if a country is not implementing the provisions of a specific treaty where the country has already ratified, any country can make a complaint or any country can inform this matter to treaty bodies. That is what interstate communication. Now, finally, there is another option, that is individual communications. If a person feels that his right is violated and this right is guaranteed in an international document, and the concerned country is still violating his right or denying that right, he can approach these human rights bodies with an individual complaint. What? Individual complaint. That is known as individual communication. Only condition is this country must be a part of that treaty and they might have ratified it. If that be the case, even after ratification, if the country has not taken any measure to implement the human right, thereby somebody suffers a loss, he can very well approach the treaty bodies with an individual communication. So these three mechanisms are very strong to ensure the international human rights are being properly and effectively implemented in the domestic level. So that is what international human rights law. Now, when we talk about international law, you will find the world is divided into 4 regions. One is European region, another is American region, and third is African region, and fourth is Asian region. Now, interestingly, these 4 regions, out of these 4 regions, 3 regions having their own regional organizations. Now, the significance of having regional organizations is they are more effective than UN when compared to that region. So, this regional organization has also created human rights documents. Most of the time, this human rights document is a verbatim reproduction of UDHR. But still, in the name of region, they have adopted regional human rights. For example, in European Union, we have ECHR, that is European Convention on Human Rights and Fundamental Rights, 1950. Then we have European Social Charter, 1999. And in American states, the organization is Organization of American States. They have American Convention on Human Rights, 1960. And if you look at African region, they are having an organization, African Union. And they have adopted African Charter on Human and People's Rights, 1981. So out of 4 regions in the world, 3 regions have adopted their own human rights. And this measure has strengthened implementation of human rights in their respective region. When it comes to Asian region, wherein India is involved, if you look at, we don't have a regional organization. So at Asian region, we don't have a regional organization. But there were many attempts to create a regional organization. At the same time, there were many attempts to create or adopt a regional human rights instrument at Asian level. But none of the attempts were successful. But within Asian region, the Arab countries have created an organization, that is Arab League. And this Arab League has created a human rights document, that is what is Arab Charter on Human Rights 2004. So UDHR and other international human rights documents plus the regional human rights instruments together constitutes human rights law at international level. So the source of international human rights law is starting from UDHR, then ICCPR, ICSSR, all the core human rights treaties, plus ECHR, ACHR, African Charter, and Arab Charter. So this is what is international human rights law. Now, if you read this international human rights law, we can classify human rights into 5 categories. One is civil rights. There are many rights which are classified as civil rights. For example, right to name, right to equality, etc. And second classification of human right is political rights. Right to vote, right to fair elections, etc. Then we have economic rights, right to work, right to trade, etc. Then we have social rights, right to social security, social welfare, etc. Then we have cultural rights, right to take part in cultural activities. So this way, human rights was developed, and now in every country, almost all the countries in the world have adopted human rights instruments in their own municipal or domestic level. Now, interestingly, the development of human rights at international level is basically classified into generations of human rights. So since we are talking about international human rights law, it is very essential to understand what are the generations of human rights under international level. The idea of generations of human right, that was created by a Czech jurist, Karel Vasek, in the year 1977. He has identified there are 3 generations of human right. The first generation was exclusively on civil and political rights. So only civil and political rights. And in that first generation, they were not considered cultural, economic, and social rights. Now, the second generation of human rights are mainly focusing on social, economic, and cultural rights. Now, there is a third generation. Can anybody tell me what is third generation? Or which type of human rights are coming under third generation human right?
So rights of the collective,
Rights of?
collective group of people, like right
Yeah.
to self-determination and solidarity rights.
Correct, correct. That is right to solidarity or solidarity rights or group rights or collective rights. So in the third generation or those human rights which are placed under third generation are rights which can be enjoyed collectively. It is not an individual right, but it is a collective right. So only through collective way you can enjoy right to development, right to environment, etc. Now, after this classification, in recent time, there is a 4th generation human right. So originally it was only 3 generations, but now we have a 4th generation human right. There is a 4th generation human right. Yeah. So 4th generation human rights are rights related to technology. Right to equality in access, computing and digital space, right to digital self-determination, right to digital security, right to access one's own digital data, etc. So at present, we have 4 generations of human right. And in some literature, I have seen there is a 5th generation, but I don't know to what extent that is correct. But majority of the literature says there are 4 generations of human right. And the 4th generation is those rights emerged due to the development in technology. So they are the generations of human right. Now, I think we have time. Can anybody tell me what is the time to how long I can continue? Bhavana madam?
Yes, Prof. So you have
you can
around
continue.
How long I can continue?
30 to 35 minutes more.
20 to 30 minutes.
30 to 35 minutes.
Fine.
Okay.
So I'll quickly rush through the UDHR and some of the main human rights instruments. We will start with UDHR, wherein, as I said, it was adopted by UN on 10th December 1948 in Paris. 58 members were the original members of United Nations, and they were present, and 48 voted in favor, and nobody got against. And as of now, if you look at UDHR, about 193 members are there. 193 members. And it consists of a preamble and 30 articles. The first and two, Article 1 and 2, dealing with the basics idea. And Article 3 to 5, dealing with individual rights. Then Article 6 to 25, exclusively dealing with civil and political rights. Then Articles 20 to 27, exclusively dealing with social, economic, and cultural rights. Then Article 28 to 29 is dealing with duties of individuals. Finally, Article 30 dealing with final provisions. Now, if you look at International Covenant on Civil and Political Rights, it was adopted on December 16th and entered into force on 23rd March 1976. As of now, it consists of 173 parties, and it contains a preamble and 53 articles, which is divided into 6 parts. The part 1 deals with right to self-determination. Part 2 deals with obligation of state parties. Part 3 deals with various civil and political rights. And Part 4 talks about Human Rights Committee, establishment and its power, functions, etc. Then Part 5, interpretations. Part 6, final provisions. The next important instrument is International Covenant on Social, Economic, and Cultural Rights. It was also adopted on December 16, 1966 and came into force on 1976. As of now, it consists of 171 parties. It contains a preamble and 31 articles, which is divided into 5 parts. Part 1 deals with right to self-determination. Part 2 deals with obligation of the state. Part 3 lists various social, economic, and cultural rights. Part 4 deals with the reporting mechanism and everything. Then finally, Part 5 deals with final provisions. Now, what are the significance of these developments at international level? This development of international human rights has significantly influenced in the protection of civil, political, social, economic, and cultural rights in many jurisdictions. If you look at many African countries' constitution, like Chad, Burundi, etc., you will find the UDHR has been directly incorporated in their constitution. Whatever rights guaranteed in UDHR is directly incorporated in their constitutions. About 20 to 25 countries have directly adopted UDHR and the rights listed in that in their constitution. And in many countries, through different legislative initiatives, either through amendments or by adopting new legislations, they have tried to give effect to human rights. So the significance of international human rights is protection of human rights in many national jurisdictions. Again, there were many countries, the rights were not justiciable. But now you will find the distinction of justiciable and non-justiciable rights are very narrow. Even in India also, if you see our part 4 of the Indian Constitution, which is a non-justiciable rights, whatever rights guaranteed under part 4 is a non-justiciable right. But at present, if I will say, I would say 90% or even 95% of the rights guaranteed in part 4 of the Constitution is now enforceable. Why? Because these rights were incorporated under part 3 of the Constitution through judicial decisions. And thereby, judiciary made it justiciable. So that was happened because of the influence of UDHR. And many national constitutions incorporated, even our constitution also. Through many amendments, many rights were incorporated by many countries. So there were significant influence in interpreting and amending or modifying national constitutions because of international human rights law. Then, international human rights law has influenced countries to adopt legislations. Even in our country also, India also, many legislations were adopted simply because of international human rights law. Then, this international human rights law acts as a base for judicial interpretations. In almost all countries, while dealing with a right, the judiciary used to find an international human rights law as its base. And thereby, they will try to develop a new right or to protect rights. Say, for example, right against sexual harassment at workplace. When a claim arises in India through a case, whether we have a right against sexual harassment at workplace, Indian judiciary referred international human rights law and thereby created a new fundamental right in India, that is right against sexual harassment at workplace. So likewise, in many countries, judiciary has considered international human rights law as a base for interpretation, either interpreting their constitution or interpreting legislation or creating new right. That is the whole significance of our international human rights law. Now, coming to the last part of my discussion, application of human rights in India. What do you think? In India, do we have human rights? Can somebody enlighten me? Do we have human rights in India?
Yes, sir.
Yes, sir.
What is the basis of human rights in India?
Human Rights Protection Act, 1993.
Yes. Human Rights Act, Protection of Human Rights Act 1993 is there. Do you really think in India human rights are available? Do anybody having a different opinion? Even though we have Protection of Human Rights Act, human right is not applicable in India. Anybody having that opinion? Okay, I'll tell you. See, if you look at Protection of Human Rights Act, we have a definition for human rights. Under section 2D, you can see on the screen, human rights means the rights relating to life, liberty, equality, and dignity of the individual, guaranteed by the Constitution. Constitution means Indian Constitution. Or embodied in international covenants. That means international covenant, whatever rights which are mentioned in the international covenants, are enforceable by courts in India. So, in India, human rights means those rights guaranteed in the Constitution. Secondly, those rights listed in international covenants. Now, what is international covenants? There is a definition under the Act, section 2 clause F, which says international covenant means ICCPR and ICESCR and such other covenant. Central government through notification will specify. Now, interestingly, I couldn't find any such notification issued by central government. So, in the absence of a notification, as of now, in India, human rights means those rights guaranteed in the Constitution, either Part 3 or Part 4, plus rights listed in ICCPR and ICESCR. So if there are any rights which is not covered in the Indian Constitution, not covered under ICCPR or ICSCR, that human right is not a human right in India. That is one point. Now, for the enforcement of these human rights, the Act establishes three mechanisms. One is National Human Rights Commission. Second is State Human Rights Commission. And third is Human Rights Courts. Now we have a National Human Rights Commission, and every state has established State Human Rights Commission. If you look at Human Rights Court, none of the Indian state had established Human Rights Court. None of the Indian state. Except Karnataka state, there was an attempt to notify human rights courts. But for all other states in India, till now, even after many years, maybe 30 years, 32 years, or 42 years, none of the state has established human rights court. So that is not available. We have only National Human Rights Commission and State Human Rights Commission. Now, what are the functions of this commission? What this commission does, that holds significance. If you look at section 12, you will find one of the most important purpose or function of this commission is to inquire either suo motu or on a petition with respect to violation of human rights. Violation of human rights. Or negligence in the prevention of such violation by a public servant. Look at here. Commission having the function or jurisdiction to entertain a petition limited to those human rights violations done by public servant. That means in India, one can claim human rights only against a public servant. You cannot claim human rights against a private entity or individual. See, we are saying human rights are inherent, everything we said. But in India, a law is there which specifically says human right is applicable only in case of violation by public servant. Either he directly commits or abet, or there is a negligence on his part. So this is why I am having the opinion that in India, human rights are not in toto applicable. Whatever international human rights law is there, that is not directly applicable in India. That doesn't mean these human rights are not covered in India. When I am saying not applicable, doesn't mean it's not covered. Whatever human rights are created by international human rights law is applicable in India. But it is not in the name of human rights. Why? Because this Protection of Human Rights Act 1993. By enacting this legislation, first of all, the legislature has given a narrow definition for human rights. Secondly, the legislature has limited remedies only against public servant. So thereby, they excluded application of this act to private parties. So that human rights are something which is a business between a person and public servant. So this is the point which I want to highlight. In India, we have human rights, but as per the statute, it is applicable only against public servant. But nevertheless, we can claim whatever rights mentioned in the international human rights law. That is because we have many other legislations. Though it is known as statutory rights, through that statutes, we can claim the human rights listed in the conventions. Say, for example, right to equal pay for equal work. It's a well-known human rights guaranteed by ILO and many other international documents. Now, we don't have a human right as such, but you have a statutory right to equal pay for equal work, because we have a legislation. And against government, we have a constitutional provision also. So you can claim remedy. So likewise, whatever human rights are listed under international human rights law is available to Indians, but not in the name of human rights, but in the name of fundamental rights or statutory rights. Like right to compensation. One can claim right to compensation as a fundamental right in India. But in fact, this is a human right guaranteed under UDHR. So likewise, we will be able to claim all international human rights in India, not in the name of human rights. And we will not be able to enforce human rights, but we can enforce in the name of fundamental right or statutory right. One limitation is, if you are going to enforce fundamental right, a human right in the name of fundamental right, you can enforce only against public entity or government. And if you are going to enforce human right in the name of Protection of Human Rights Act, you can enforce only against a public servant. Now, if you look at our judicial perspective, many decisions have said our fundamental rights are equal to human rights. They are also natural rights. Natural rights are human rights. Like that, many observations were there. That means our judiciary is not considering the distinction between human rights and fundamental right. They are considering it as a fundamental right. Now, one of the challenge, one of the practical problem in that approach is, if you treat a right as a fundamental right, your opposite party must be an entity coming under Article 12 of the Indian Constitution, that is state. So that means you can claim human right in the name of fundamental right only against a public authority or a public servant. So human right having a limited application in India, to the extent you can claim only against state, including public servant. And if you want to claim human rights against a private party, there are certain legislations like right against sexual harassment, that POSH Act, or Equal Pay for Equal Remuneration Act, etc., wherein you will be able to claim human right, but in the name of statutory right. Except those exceptions, in many of the cases, in India, human rights can be claimed in the name of fundamental right, and that too against an entity falling under Article 12. So this is the position of human rights in India. So with this, I would like to conclude, and I'm happy to clear your doubts or clarify whatever you want. Thank you. The floor is open to the participants.
Thank you very much, Dr. Pillay. That was very interesting. I think you started from scratch, from the basic knowledge of human rights, taking us to a very critical perspective of how it is. Now I will open the floor for question and answer session. So you have 30 minutes for every interaction that you would like with the speaker. Please raise your hands, or the floor is yours. Thank you. Yes, so I think we have a first question from Dr. Rakesh Kumar Sehgal. Yes, doctor, you may ask your question. Yes, Dr. Sehgal, are you here? Can you hear us? Okay, while waiting for him, we have another question from Assistant Professor Loveltek. Yes, sir. Are you unable to unmute yourself?
Our participants can also use the chat box if they want.
Yes,
And
I
I
see.
think there are few
So,
comments in the chat box.
okay, so we'd like to welcome questions from others in the meantime. Any questions?
Hello, am I audible? I would like to ask one.
Yes, you are,
Please,
please.
go ahead. Go ahead.
Yes. Will CPC, that is, CPC will take over, take care of civil rights? Will that right will also be called as human rights? I'm Sujit from Hindustan Institute of Technology and Science and PhD scholar of Vikrant University, Gwalior.
Okay.
Yes, I'm. This is my thing, sir. Will that right
So,
be called as human rights as well, civil rights?
see, the point is CPC or Civil Procedure Code is not directly guaranteeing any rights, except one or two rights like a right against imprisonment for inability to pay debt. Otherwise, CPC is something which regulate the procedure in civil courts. So it is not basically a document which guarantees rights. But while regulating the procedure, it guarantees certain rights. That is a statutory right, whether it is human rights or whether it is civil rights or political rights. That classification is not required there. It's only certain rights which are there for ensuring procedural fairness. Okay.
Thank you, sir. Thanks a lot.
Yeah.
Okay, so Dr. Pillay, we have 3 questions in the chat box, so I'll read them out to you. So we have a first question from Vijay Kumar. Could you highlight something about fragmentation of human rights? Is it necessary in the current times?
I couldn't understand that question, but what he meant by fragmentation, in what
Mr.
sense?
Vijay Kumar, if you're here, could you clarify?
Ma'am,
Hello. Yes, madam.
Okay.
Yes, please clarify your question.
Yeah, can you hear me?
Yes, please.
Fragmentation is like in today's context, human rights has become bottomless barrel where each and everything about the rights perspective is being put or claimed. So that's where the human rights has become like a vague term in modern time. So there are talk among scholars of human rights. They say that human rights should be have a comprehensive understanding rather than the bottomless barrel understanding.
See, if you look at the human rights, it is like that, and it will continue like this only. The reason is we don't know what makes a person happy in his life and what makes a person's life better. That person only knows. Whatever rights I will receive, that will make happy for me, but that may not be the same with other person. So it is individualistic in nature. So human rights are vague, and it will still continue like that only. The reason is every human is not similar. Everyone having some or other difference because of many reasons. So the rights and the content of the rights will also change in accordance with that. That changes makes the human rights in that way. That vagueness comes from the content. I will give you one example. If you look at a right which we are talking in our country, and if you compare the content of this right with other countries like European country or an Arabian country, you will find a totally different content. Simple example is right against torture and inhuman treatment. It is one of the fundamental human rights guaranteed in ICCPR and UDHR. Now in India, we have a an understanding about what is right against torture and what should amount to torture and what should not amount to torture. But if you apply this content to many other countries, especially Arabian countries and European countries, then you will find a large scale difference. Got it? So based on the country, based on the culture, economy, technology, political understanding, the content of human rights will change. So it will still continue as a vague concept, but that idea is very central, the human rights. That will continue without any change. Hope I have answered.
Thank you, sir. Thank you. Thank you so much.
Okay, thank you, Dr. Pillay. So we have a second question. This is from Mauritius, from Mr. Yograj Sibalak. So he's asking, what measures can the government of Mauritius take to ensure that human rights enforcement is properly empowered and respected, especially when recent actions by law enforcers appear to contradict these policies? So
I think you can answer. I think you can answer this question. I'm not well versed with Mauritius perspective.
Okay, so we'll move to the next question. Sir, please tell me the book on international humanitarian law or any other reading that you can suggest.
See, for international humanitarian law, in India, we have one well-written book that is written by M.K. Balachandran and Rose Varghese.
If
It's
you
a
could
collection
provide
of
in the chat box, Dr. Pillay, would be nice so that we can have the reference as well. So I see we have one raised hands from Sumaya.
I'm sorry to interrupt. It is for the information of the participants that on international humanitarian law, we have a special dedicated session on the December 16th to be delivered by Professor Maruti Tier from University of Mysore. So you can put those questions to him also.
Okay, yes. So in the meantime, Dr. Pillay has provided us with one suggestion, which you can use in the meantime. And sorry, we have one more question from Remia Prasoon. What is the reason for not bringing up human rights court in India?
Two reasons. One of the major reasons is the purpose of human rights court is to deal with human rights cases. If you look at section 30 of the Protection of Human Rights Act, you will find that the purpose is to deal with human rights cases. Now, what constitute human rights cases? Nowhere it is mentioned. And how you are going to identify human rights cases. And if you read any case or if you deal any case, you will find a human rights violation in that. So in that context, identifying human rights cases for the purpose of exercising jurisdiction by human rights court is very difficult. That is one major challenge. Second problem what I could find is the resources. We have many number of courts, and every time we are seeing the criticism, the seats are vacant, the judicial officer seats are vacant, and there is no proper recruitment. So in that context, if we establish a new court, that will provide additional financial burden to the state. So what the states will do in India, they can simply designate an existing court as a human rights court. And I think Karnataka High Court has once did this. And there was one case which was decided in the name of human rights case. That was happened. But in many other states or all other states, they haven't taken any measure to at least to notify human rights court. As maybe the district court as the human rights court, they haven't done. And there is no measure taken by National Human Rights Commission or state commissions to identify, or even the concerned government, to identify what constitute human rights cases. So I think that is the reason, or these two are the reasons why human rights courts are not established even after 3 or 4 decades.
Okay, so we have another question. What human rights obligations do corporations have when deploying AI in hiring and workplace monitoring?
See, it is simple. It's every human rights are applicable there. It's not, only thing is, what is new in this is incorporation of AI. Whether you are incorporating AI or not, whatever human rights instruments are there, whatever rights are available to the employees, that will keep continuing. And if there is any interference with human rights, then the concerned authority can interfere with that. Say, for example, I am incorporating an AI integrated machine in my workplace. And as a result, maybe there were 5 or 6 employees who were working in that field. But by the incorporation of this AI mechanism or AI integrated tool, I can reduce the work to 1 person. So if I am terminating the remaining employees, automatically they can file complaint. And there are many labor law legislations which helps them to secure their tenure. So they can immediately file a case against. So likewise, whatever way AI will affect, whether it is employment, whether it is health, whatever it is, the corresponding law they can use. And there will be human, if there is a human right violation. I hope that is clear.
Yeah, and we have one last question. Why has India not ratified the optional protocol to the International Covenant on Economic, Social and Cultural Rights? Is there any specific reason?
Which is this optional protocol you are talking about? Can you please clarify?
Mr. Sham Kalita, could you please clarify?
Sir, there is, good afternoon, sir.
Yes, please.
Sir, there is the optional protocol on the International Covenant on Economic, Social and Cultural Rights, under which the individual can directly file the case to the Human Commission relating to the violation.
Which optional protocol is this you are talking?
Sir, first one.
First optional protocol of ICCPR or ICSR?
Yes, sir, ICESC.
Yes,
Right.
Okay,
Yes, sir.
fine.
Yes, sir.
Fine.
Thank you, sir.
See, yeah, the reason is very simple. The reason is very simple. What is contained in ICSER? The rights guaranteed in Part 4 of the Indian Constitution. That is economic, social and cultural rights. Now the problem is, if you ratify this optional protocol, then Indian citizens will get a right to file complaint before the committee of CSER against India. Now, the rights which are guaranteed in ICSSR is depend on the economic resources and other infrastructure existing in the country. Since our country is not in a position to ensure that, till then, the moment India feels that we can do that, then immediately we will sign it. That may be the reason. I don't know, is there any other reason? But I find that this resource crunch is one of the major reasons for not accepting any obligations based on social, economic and cultural rights. And one more thing I'll tell you, even though we haven't ratified this one, all the rights which were there in ICSSR, ICESER, that is applicable in our Indian Constitution under Part 4. Now, whatever rights are there in Part 4 is made justiciable through judicial interpretation in Part 3. So, in reality, in India, we don't have any distinction between civil, political, economic, social rights. Now, everything has got the status of fundamental rights. So, I think that may be the reason why Indian government is not taking an action.
Okay, sir.
Okay.
Thank you, sir.
Thank you, Dr. Pillay. So we have one raised hands from Sumaya Kanita. Can we hear from you?
Yes. Okay.
Sumaya. Could you please unmute yourself? Okay, so I think she's not able to do so. So this is where we come to the end of today's session. So thank you very much, Dr. Pillay, for your time and for all the efforts you have put into to deliver the lecture and to answer all the questions of the participants. We look forward to hosting you in the future for other events. With regards to the participants, so you have been circulated a feedback form in the chat, which you are supposed to fill in before you leave the platform so that we can mark your attendance. Thank you very much, Dr. Pillay.
Thank you for your invitation, and thank you all the participants for your patient listening to me. Thank you.
Sir, thank you, sir. It was really
Thank you,
enlightening.
sir. Thank you so much.
Thank you, sir.
Thank you, sir.
Dr. Jayanta, the participants are saying they are not able to fill the feedback form. They're not able to access it. Could you please look into it?
Ma'am, recently this issue is there with Google Meet. In my phone, it is not opening. So no issues. I will send a feedback link in the WhatsApp group. Your attendance has already been recorded by the Google Meet itself.
All right. For some, it's working. For some, it's not. So we will be circulating the feedback form in the WhatsApp group. You can fill it from there so that we can mark your attendance to receive the certificates later. Right? So thank you very much, everyone, for your attention. And we are going to meet again tomorrow. It is for those who will be starting. Yes, Dr.
2:30
Jayanta.
Indian time and 1 p.m. Mauritius time.
Exactly. This is what I was about to say. So tomorrow we are going to have another international speaker from Germany who will be taking up another theme for the faculty development program. Thank you very much and see you tomorrow.
Good man.